which involved the issue of a rule nisi. The present application was brought on the basis of urgency, seeking inter alia a declarator to the effect that the rule nisi issued by Mjali J on 7 April 2022 extends to the lawfulness or otherwise of the attendance by branch delegates for the Dr. W.B. Khobesana region at the ANC's provincial conference scheduled to commence later tonight. The applicants also sought originally to interdict the participation of the above delegates at the conference itself, only to abandon this prayer in argument. The rule nisi invited the respondents to show cause on 3 May 2022 why a final order should not be granted to the effect that the branch biennial general meetings, BBGM, and branch general meetings, BGMs, of the ANC held in the Dr. W.B. Khobesana region during February and March 2022 were conducted unlawfully, that the decisions of the above meetings were void, that the ANC regional conference for the Dr. W.B. Khobesana region be interdicted pending the finalization of all internal appeals and compliance with the provisions of the ANC constitution, and that the ANC ensures compliance with its own constitution and resolves the cause of the applicant's complaints. So much for the rule nisi. The holding of the ANC regional conference was interdicted with immediate effect. The provisions of Rule 612 govern the situation at hand. To that effect, Sub-Rule B requires an applicant such as the present to set forth explicitly the circumstances which render the matter urgent and the reasons why the applicant could not be afforded substantial redress at a hearing in due course. Here, the applicants instituted proceedings under the main application on or about 4 April 2022. The respondents opposed the application and filed their answering papers on or about 5 April 2022. To that effect, they sought the dismissal of the main application with costs. The applicants consequently filed their replying papers on the same date. Mjali J issued a rule nisi on 7 April 2022 with 3 May 2022 as a return date. On 3 May 2022, the matter was postponed until 31 May 2022 for argument. From the present application, it is not clear when the applicants first became aware of when the provincial conference would be held. For an event of such magnitude and importance, it can be safely assumed that the applicants have not just come into knowledge thereof. The date would have been known well in advance. Importantly, the applicants were aware by as early as 5 April 2022 of the respondents' stance in the matter. From their answering papers, they very clearly opposed the relief sought by the applicant. It is not evident from the applicant's papers in the present application why they waited from that date, the date of the order, 7 April 2022, until late last week, the week that has just passed, before doing anything about the situation. If the applicants have properly considered their position in relation to the opposition demonstrated by the respondents, then it would not be unreasonable to have expected them to have taken further steps well in advance of the date of the provincial conference. Instead, the present application was brought replete with shortcomings. The relief sought in the notice of motion is far from clear. No amendment was sought to clarify its meaning, and the applicants relied instead on council submissions from the bar. The present application is based on the founding affidavit of the first applicant. There are no supporting or confirmatory affidavits from the remaining applicants. No reference is made to the annexures, and the court is left to second guess their true import and relevance. The date itself of the Provincial Conference is not mentioned, as pointed out correctly so by the Respondents' Council. In short, the papers fail to dispel the impression that any urgency that attends this matter was entirely self-created. The applicants have failed to satisfy the requirements of Rule 612B. Crucially, they have failed to demonstrate why they would not be afforded substantial redress in due course. If the applicants are indeed of the belief that the attendance of the branch delegates at the Provincial Conference would be unlawful, then nothing would prevent them from taking the decisions to be made at the Provincial Conference on review at a later stage. However, pending the court's determination of the issues pertaining to the Rule Nizai in the main application, the applicants have not indicated a basis upon which this court can be approached on an urgent basis for the relief sought. In the circumstances, the court is not prepared to deal with the matter any further. The respondents sought costs for two counsel. The court is not of the view that two counsel were warranted. Consequently, the following order is made. A, the application is struck from the roll, and B, the applicants are liable for the wasted costs thereof. The court is adjourned.
There you have heard it, that urgent application to interdict the ANC Provincial Elective Conference in the Eastern Cape has been struck off the roll. Continuing